one of the learned lawyers in Nigeria who is grounded with the knowledge of law, breaks silence and criticized the judgment delivered by Justice Omotosho against Nnamdi Kanu. He maintains that the judge sentenced Nnamdi Kanu to life imprisonment unlawfully, and he demands that the Supreme Court should revert that judgment, pointing out so many flaws in the judgment that the judgment should not even stand in appeal court and get reversed. Just watch the video to hear it in details.
There's an absolute miscarriage of justice in that case. There's a miscarriage of justice because if you look at it, ex nihilo nihil fit. Nothing comes from nothing. You cannot pull something from nothing. Nothing is equal to nothing. Okay. It's a judgment that is delivered per incurium, which means that the judgment itself did not follow the basic legal principle for which it ought to have followed. Now, when you look at the spread of the case, there are three fundamental issues. First, the law upon which he was charged had been repealed. Okay, so the statutory absence of the existence of that law itself, foils that issue. Okay. Two, the objection raised by Nnamdi Kanu in terms of the objection that relates to that the court lacks jurisdiction to that effect was not adhered to by the judge. Primary objection under the law, once it is brought, the law says that it can be raised at any point before judgment. So, and once it is raised, the court must first of all suspend whatsoever it is doing to attend to that. When the issue of jurisdiction is raised, the court must first of all assume jurisdiction to determine whether it has jurisdiction or not. That was not done. Okay? Then the third one has to do with proof beyond reasonable doubt, the material evidence, the nexus, that the unequivocal evidence that's supposed to link Nnamdi Kanu to the charge was not there. Like the lawyer said, there was no weapon. Even when you go beyond that, there was nothing direct. You are saying he made this statement, he made that statement. All those whom were affected, nobody was called as witness to testify. So the court solely relied on circumstantial evidence under the Evidence Act. Circumstantial evidence requires corroboration before it can be fit for conviction. Okay? So when you look at the case in its totality, this three defects deflates the argument put forth by that judgment for the conviction of Nnamdi Kanu. In criminal cases, the law says that you cannot charge someone for an offense not known to law, and you cannot charge someone for an offense that is not in a written law. Okay, so if you are charging someone on a law that has been repealed, and you have that in your charge sheet, what you need to do is to first of all address that as a prosecution counsel or the prosecution team, which was not done. Okay, criminal trial requires proof beyond reasonable doubt. It is not enough to say he made statements. To whom did he make the statement? Where are the witnesses? Where are the evidence? Okay, upon his conviction, on what basis are you arriving at his guilt and thereafter his conviction and sentencing? Okay, so we don't, in law, you cannot, apply speed and kill it on the altar of technicality. So the court, I absolutely agree with the lawyer that that judgment is sitting on a very wrong tripod, because by the time you clear those three angles, three aforementioned angles, there's nothing left of that judgment. Because it is political, perhaps there is a pressure to score points. But the law does not see it that way. Whether a matter is political or not, even if a matter is political, it must conform to legal process, legal proceedings. If a defendant is raising an objection, you don't say because you want to deliver judgment, you want to end the case, you go ahead and deliver judgment. When in section 36 of the 1999 Constitution, it says that the defendant must be given adequate time and facility to prepare for his defense. There are times when the judge
he was given more than enough opportunity.
No.
Especially when he said he wanted to defend himself. The judge kept telling him
when he filed the objection, the motion to challenge jurisdiction, the judge refused to hear the motion. He was given enough time to enter his defense, but he opted for a motion.
So what's the difference?
To challenge the jurisdiction. Yeah, there's a difference.
Yeah.
Okay.
You are asking him to open his defense. That's to call his witnesses that he has listed. He listed many of them. You're asking to call them and have his case dispensed with. You understand? You gave him enough adjournment on that. In the process of that, he came up with a motion. He brought out a motion. He filed a motion and said that I am challenging the jurisdiction of this court. It's allowed in law. Objection can be brought at any point before judgment.
Wow.
Yes. There are times when the judge has written a full judgment, has adjourned to deliver the judgment, and will file motion to arrest the judgment. It's allowed in law. So what will now happen is that instead of the court to go ahead to deliver that judgment, the court will suspend that judgment, the substantive suit, and focus on the motion filed. Okay? And then deal with that motion to its conclusion before it goes back to the judgment. That is the law. Okay? So if that was not followed, would you still say that the judgment is sound on that? See, judgment, however sound and brilliant, that is delivered by a court that lacks jurisdiction goes to no issue. Ex nihilo, nihil fit. From nothing comes nothing. This judgment cannot be an exception. It cannot be because lawyers just kept quiet. You can't. This is the first judgment that we are putting something on nothing and expecting it to stand. It cannot stand. This has nothing to do with emotions. And the fact that a defendant is unruly in court, uncultured and mannerless, does not give the court, does not empower the court to pass judgment against him. There are other options the court ought to have turned to by contempt, the court will have charged him for contempt or any other remedy available to the court. So because I've heard people say because he was unruly, that is why the court had to quickly. That is judicial blasphemy. To convict a man because he's unruly. No.
See, it's actually interesting, Barrister, you're saying. Yes, Barrister, sorry to cut in here. It's actually very interesting as you fleshing out some of these things and expose them as much as you can. But as a lawyer, is it fair to say that at this point you are questioning the intellectual dexterity of Omotosho SAN at this point, knowing what he had going on?
Very well, very well. What do we do on appeal? I can talk like this now because the case has ended. And they have not filed appeal. They are filing today or tomorrow. The reason lawyers cannot talk outlandishly before night because the matter is sub judice. Right now, it's no longer sub judice. And when we go on appeal, what do we say? We say, see how we couch appeal. Let me tell you how we couch appeal. The learned trial judge misdirected himself. That's how we couch appeal. When he concluded or made so that's how you couch appeal. The learned trial judge erred in law. Do you understand? So that is it. So you will see that the appeal will be framed around these three premises. It's a criminal matter, it's not a civil suit. Criminal matters that the penalty is capital. You don't treat it with kid's glove. The fact.
Since after the conviction of Nnamdi Kanu to life imprisonment, so many people have continued to condemn the judgment, that the conviction was made on non-existing law, that the entire judgment was total flaw, and yet the judge went on to sentence him to life imprisonment without citing any section of the law in our constitution. The only proof the judge could mention was that Nnamdi Kanu insulted him. He thereby sentenced him to life imprisonment. Listen to so many opinions and condemnations concerning this judgment against Nnamdi Kanu by this judge, Justice Omotosho.
The Igbos have been marginalized. Look how come on, how do we explain this judgment after 10 years? How? How do we explain this? No, well, I said they should be calm. But, well, they are calm. But you are calm in the face of injustice, and it's going from generation to generation to generation. Abba, when are we going to correct this? When are we as a nation going to correct this? How can we be in sin and expect His grace to abound? A nation in sin and is expecting development, is expecting growth. You are telling a whole region, just stay calm, don't worry, stay calm. And now they've transferred the guy to Sokoto State. Abba, Igbo man, Igbo prisoner sent to Sokoto State. Is that, come on, how do we explain this? Kidnappers, bandits, you rehabilitate them, put some in our army, put some in a good position. But this guy, for 10 years, can't you say, oh, you've been here for 10 years, go out, go and see no more. So now you are, how do we explain jailing this guy for life? How?
There was a conviction recently of a terrorist, Boko Haram. I believe his name is Husseini Ismail. He was convicted for 20 years by a high court. He was a Boko Haram terrorist. Mazi Nnamdi Kanu was convicted, I think, last week, and his own conviction said life sentence. I don't understand why one terrorist is getting 20 years and the other is getting a life sentence if you're saying that. I think Pastor made a good point. There's this idea that justice is served differently, and it affects the problem. Mr. Speaker, I'll conclude by saying this.
Now, the whole issue about Nnamdi Kanu's matter bears a lot of questions and defeats a lot of logic, because a lot of people, even Nnamdi Kanu himself, had continued to say it, even rambunctiously in court, that they should show him the law with which he's being tried. Because by the time many people didn't understand, because all the people who were not privy to the charges and people who were not privy to the goings on in court were at a loss as to why would a man be charged for an offense that is not known to law in a criminal trial. Because a Nigerian statute book says that one cannot be tried for a law of an offense not codified and known to law.
Yeah.
And then
under the principle of fair
hearing,
sections 35 and 36.
Absolutely. And there is nothing like retrogressive action in law when it comes to criminal action. Yeah. We are not a military regime.
Mr. Adams Soshomole also condemned imbalances in the justice system of Nigeria. He questioned why did the judge sentence a Boko Haram member that has killed thousands of people to only 20 years imprisonment, while in the south they sentenced Nnamdi Kanu to life imprisonment for agitating for Biafra.
How can an offense that carry death penalty, a judge reduce it to 20 years in prison? That is not acceptable. He has violated the laws passed by the parliament. Number three, sir, and this will be the last.
Has that happened in Nigeria already?
It has. Somebody convicted of terrorism was sentenced to 20 years in prison. When the law says act of terrorism, if convicted, shall attract death penalty, no judge has a right to pronounce less than that. It is only when you have implemented the law, interpret the law, not the sentiment of a judge, the will of the people as conveyed in a law, then the president can decide if there are reasons for him to do so, whether to commute or to reduce. Death penalty on terrorism. This parliament is on record as having done that. Mr. President, I am troubled